Good morning, everyone. I hope you're refreshed after the coffee break. We are now going to have a hopefully very nice, I'm quite sure, very nice panel on challenges and implications of emerging technologies in armed conflict. And it's my pleasure to introduce Magda Pacholska, who will speak first. Magda is, no need to introduce her to you guys. She's your very own postdoc at the Minerva Center for the Rule of Law. But she also holds her degrees not only from the Hebrew University of Jerusalem, where she obtained a PhD, but also an LLM from Amsterdam University in cooperation with Columbia. And she also spent some time as a Marie Curie postdoc fellow in Amsterdam. But she's now back to Israel, and she will talk about facial recognition-based targeting under international law. Magda, over to you.
Thank you, Zuzana. It's actually not quite accurate. I'm not based in Israel, but it's fine. It's a very logical assumption. Okay, so good morning, and thank you for sticking with us for the last 3 days. I know it's been a lot. This presentation is about facial recognition-based targeting under international law, and I have to start with a disclaimer that this is a presentation based on a paper Ido and I co-authored for the International Review of the Red Cross on the special issue on military approaches to IHL. Yeah. Military law, something like this. It's coming out early next year, so check it out. One can only hope. Okay. I don't know why I'm the only one on the agenda.
Just click on it on the right, on the...
This one.
Yeah, okay, you're good.
Okay, so a brief overview of what I'm going to talk to you about today and how the paper is more or less constructed, even though it's been revised about 13 times by now and it's a little bit of a unicorn with wings. But this was the idea of how the argument was supposed to be structured. So we start with the state of the play, providing the overview of what's out there and how it's used by the armed forces, what type of technologies relying on facial recognition are these days actually used rather than we think are used based on sci-fi movies. Then we moved on to the operational and conceptual framework before zooming into specific human rights questions, especially the right to privacy and the right to life. So I'm very glad this is the presentation is today, after we already had some discussion on both concepts over the last 2 days. Then we move to everyone's favorite targeted killings and questions related to it before closing with conclusions. Now, you cannot leave me now, this is your part. This is the tech part. But there are a few things we do not cover in this paper, and I think it's important to mention. It was never our idea to provide a comprehensive overview of state duties and obligations with relation to the use of facial technologies. In particular, we don't write and analyze questions related to the collection of data, storage, and processing. There is plenty of this written already. And should you be interested in this, there is a special issue on biometrics in general, published by the Military Law and Law Support Review, a little bit of self-promotion. Part of it, most of it is open access, so I invite you to read it. So this is something we do not deal with. We actually focus on the combat employment of facial recognition technologies. But we acknowledge that there is a variety of national and international law issues related to the collection of data needed to do that in the combat employment. Do you want to cover the facial technologies?
You can if you want, but...
Okay. So facial recognition technologies is actually an umbrella term to refer to a bunch of technologies with different levels of sophistication. The basic one is what we, at least most of us, have on our phones. When you unlock your phone with your screen with your face. But this is the basic, this is a very basic level. What's used in combat, but also by the police in many cases, are technologies relying on facial topography, which is the picture you see right now. There are 4 steps required to get to this level of sophistication. You can see them listed here. But the crucial aspect from the technological perspective is the face print. And this is what's actually compared. the different points on a face, which are translated into mathematical algorithm. Now, we started this paper, I think, sorry.
Yeah, I've already.
Thank you. We started drafting this paper, I think, in the summer 2023, and then continue through after the 7th of October. And what I'm trying to say is it was not our trigger to write this paper, the information about lavender and gospel. That's not where we started. And given that many of those, much of this information is still not confirmed by the IDF, we're trying not to write an opinion piece on those technologies. We're trying to deal with the concept and the issue as such. So we approach this from the perspective, more historical perspective of what has been done by the coalition forces, mainly Afghanistan, which was the first main theater where facial technologies, facial recognition technologies, and biometrics in general were used. It is part of a larger trend to leverage biometric to establish identity dominance over the enemy. In much of the literature on the topic written by military experts, they acknowledge that anonymity is one of the greatest weapons on the modern contemporary battlefield. So to balance it out, if you can identify your enemy, it's the value in itself. I still think there is no documented specific use of facial recognition for targeting. There is some information, mainly by the US, in their unclassified documents that they use biometrics for targeting purposes, but we don't know exactly which ones. Now, it is interesting to know that from all the biometrics, including gait, iris, and facial recognition, fingerprints, help me out.
Etc.
Yeah. The facial recognition is the least accurate one. Yet it's particularly apt to be used for targeting because, unlike the others, can be collected from the distance. So your enemy does not have to know that you have this data. So it's easier to collect, easier to use, easier to store. Now, there are two main uses of biometrics. This is a broad distinction and obviously hotly debated in literature. And this is a distinction between biometric identification and biometric authentication. You can find about 18 different approaches. So where is the dividing line, whether there should be two distinct categories. I don't think it matters that much from the legal perspective. But the biometric identification is where you try to identify a person apart from the others. And authentication is you want to confirm the identity of the person. So authentication is what you do with your iPhone, pretty much. Which one is looking for the hey?
Identification.
The identification.
Looking for a specific hay in a haystack. You're looking for one person out of many.
So you know who you're looking for.
Isn't the metaphor a needle?
Needle
rather
is
than a
easy
hay?
through technology. It's easy. You just use a magnet and it comes to you.
Sorry.
So you need to find a specific hay in a haystack. That's the challenge.
Funny you should mention it, Marco, because it was one of the hotly debated points with our reviewers for this paper.
Yeah.
Of all the things you can possibly disagree about, this was one of them.
The expression?
Yes.
And now I think it was Marco.
Oh. I'll never be so petty.
Somebody was. Anyhow.
But you still need to know what the hay looks like ahead of time,
You're
right?
looking for
It's not-
specific.
Yeah, no, so you don't just
Yes.
want. Okay.
Correct.
You need to say, hey, that's the hay.
Now I wish we could add that. Part of the paper deals with demystification of technologies and points out the difference between what's actually being used and how, and what many people think is out there. So we point out that facial recognition technologies, like many technologies for targeting, are used as a complementary source of information. It's rarely the only one, the only piece of intel you have on your potential target. And it's used to build layers of knowledge about an asset. We had a little bit of a discussion whether or not it's more useful as a technology in NIAX versus IAX, but we will get to this in a second. It is our starting point of reflection that IHL is technology neutral, and I think this is an important point. So what this entails is that we assume that IHL is already built on a balance between humanity and military necessity. Therefore, we don't treat humanity and other ethical concepts as self-standing principles which should prohibit anything. We think it's already built into the legal system as such. Obviously, there was a discussion about how much time we should spend about the never-ending discussion on the interplay between IHL and human rights law. But we all know that there is enough written up about it. We figured maybe not. But we also agreed, and I think this was one of the sticky points for the review, is that there's a sliding scale of obligations when it comes to human rights law, meaning the closer to the battlefield, the less amenable some human rights are to reasonable applications. There is a major discussion about the idea of derogation, especially when it comes to the extraterritorial application of human rights. So the question is, and this is something we didn't solve, we just marked this as a big question, can a state which somehow is on the way to exercise effective control over external territory derogate from its obligations? So whether the concept of derogation is limited to state proper territory, or can it be expanded further? There is some discussion about it in biometrics with reference to privacy, but I don't think we're nowhere close to solve it yet. And here comes the slide where Markov bites my head off. And this is the extraterritorial application of human rights. We zoomed into the two, as I mentioned before, the right to privacy and the right to life. And we made a distinction between attacks happening in the territory of a state versus attacks happening outside of the territory of the state. And here comes the question of the applicability of human rights extraterritorially. This is one of the, no, I backpedal on this. I wanted to say most contentious case of the ECHR, but there are so many, I think it's hard to pick the most contentious one. And I know no one likes slides with too much text, but I figured that given that Mark was in the room, we need the text. With quotes and numbers of specific paragraphs. But basically, the takeaway from this judgment is that in the context of hot hostilities and ongoing chaos that comes with, the state cannot be assumed to cannot have effective control, because this is what the battle is about. So if there is no effective control, there can be no application of this. The invading state does not yet have effective control. Therefore, it cannot have obligations, human rights obligations towards the population. We're talking about the active hostilities phase, where the targeting with the support of face recognition technologies actually takes place. And just to answer a follow-up question, whether there can be other bases of jurisdiction, just such as state agent authority and control, the court helped us out a few paragraphs later, and here is paragraph 137, when this is also explicitly excluded. Now, in all fairness, the court has been less than clear about the right to life in the same case, just to be, to make things more convoluted. When it comes to people held, kind of POWs and others held by the invading forces. And this is an exception because they're already within the authority, I guess, of state agents. But so there's a lot of critical writing on this decision, as it is on many CHR cases. And we'll see whether this is going to be reversed. But for now, there is no case where the court decided to reverse this standard, even though it had an opportunity. So for now, this seems to stand. The takeaway for our discussion is that we don't really have to spend too much time on the question whether or not the use of facial recognition technologies for targeting violates the right to privacy, because it doesn't apply at this moment. I know it's an easy way out, but the court has been clear enough. Yeah?
Just on the technical aspect, one of the ways that technology uses face recognition technology is what is referred to, if I remember correctly, the ping and bell, which means that ping and ring. If I want to have information about someone, I get that person's photo and I send it to another system which has all the face print of that person. And only if that person actually appears in the big database, they will let me know, and then I can ask for the rest of the information. So there is a separation of information which helps with the privacy issue of separating between different systems about, and it's usually not one system that holds the entire information about all the faces of all the persons that I'm looking for.
What's the alternative to what you're describing?
One system, I get all the information of all the people in the room, and then I look if they fit to everything I want, and then I get all of your information into, instead of asking Ziv, do you have in your database anyone that would fit to this specific face print? And if so, please give it that one to me.
Do you want to cover your favorite part?
No.
Okay. So now, remember this dealt with, this is the relevant context here are extraterritorial attacks. I think there is no discussion that the state has obligations towards to comply with the privacy rights of within its territory, within its jurisdiction. So this discussion was limited to extraterritorial attacks, which are attacks.
So to you, it's normal that Ukraine needs to respect the right of privacy of Russian troops on Ukrainian territory, but that Russia doesn't have to respect the right of privacy of Ukrainian troops on Ukrainian territory.
In this question,
that makes sense.
In this question, you assume that Ukraine has effective jurisdiction over Donbass. I don't think it does.
But surely there are some Russians killed in some areas that are still under Ukrainian control. Surely they killed some people in parts of Kursk.
In targeted killing based on face recognition
well, they probably didn't kill anyone like that. So if you're talking about a
yeah, exactly.
Exactly. Following
so, but she said it's good. That's the thing.
Okay, but let's keep the question to that.
It makes sense. That's my view.
Don't voice an opinion. Just
ignore up until the Q&A.
Yeah.
No, but this is a good question, and I think that if
we'll get it in the Q&A.
Okay, sorry. I expected this. I expected this. All right, so back to the territory of the state. Now, and this is one of those things that was added during many rounds of reviews, is the right to life and the problem of false positives. The false positive is when a system incorrectly identifies a target as matching database, and this is wrong. So we're attacking someone we didn't want to attack. And the question is whether this can be qualified as, so we have two questions here. One is IHL-based, the other one is human rights-based. The human rights-based is the question whether this situation can be described as arbitrary deprivation of life. And of course, no, in a second. This is the situation, this is the moment when the interplay is between IHL and human rights law is supplemented by everyone's favorite GC 36 of 2019, when the Human Rights Committee decided to make our life even more complicated and said this: the use of lethal force consistent with IHL and other applicable international law norms is in general not arbitrary.
Not arbitrary deprivation of life.
Yes. What do we do with it, given that this is a full stop? From our perspective, this is where you start with the question whether or not this would be a violation of IHL. So much depends on whether the commander, those who plan and decide on attacks, did everything possible to comply with the obligation to verify targets, given the circumstances ruling at the time. I think it's broadly agreed that the absolute certainty regarding whether the target is a military one is not a required standard. It cannot possibly be. Here we go into the question of honest and reasonable and honest and unreasonable mistakes. But we can imagine a situation when this is an honest and reasonable mistake. Therefore, it's not a violation of IHL. How do we handle the in general part here? We don't really know. We think it's one of those aspects of international law, and we have to wait a little bit more and see how this develops. For now, there is just not enough information to get in general in a reasonable direction, which is based on in compliance with the methodology of public international law. Let's put it this way. Now, having discussed all this, let's move to an actual use of facial recognition technologies for targeting. And obviously, it's going to be effectively a targeted killing situation, or what we like to call identified killings. And in the ideal targeted killing situation, no, one more thing. We all know that targeted killings is not a term of art of IHL, but it's been developed over the last at least 15 years, 20. So I think as a concept, it's there. There's plenty of discussion as to the circumstances in which it's lawful. So we decided to make our life easier and imagine an ideal targeted killing situation. So we don't want to deal with the aspects that have been discussed with reference to targeted killings for the last 20 years. We want to focus on this, technology-based question. So in our ideal targeted killing situation, the designated target is a legitimate military objective. There is imminent necessity to neutralize them. There is no excessive collateral damage. And the fourth, no lethal alternative wouldn't neutralize the threat. So in this kind of operation, the crux of the issue is the positive identification, either by human sentries, which come with a certain risk and raise issues of force protection, or by our focus here, facial recognition technologies. There are two main legal questions here. The first one is the tension between human rights law right to privacy, assuming it applies, so within the territory, arguably, but yeah, assuming it applies. So there is a tension between the right to privacy and the human rights obligation to verify the targets. Meaning, how do you balance your obligation to do everything feasible to make sure that the target is a military objective, which is your obligation under IHL, with the right to privacy of the enemy population, the belligerent, like the other side. I personally, I don't think anything. It's a question.
It's not good. It's not bad. Just presenting the situation.
It's a question. No, go ahead.
Are you talking about the right to privacy of the population in the sense that you need to collect all their information in order to have the database to compare with?
Mm-hmm. That's why I thought something, but I won't share it.
No, I just wanted to know what the issue might be. Okay.
Yes.
If Marco would agree not to comment, would you share your opinion?
Oh my God. I adore.
Equality of arts. You're so big on that, and now you're
Looking at you.
I'm gonna shut up. Okay, I'm not gonna say a word. I'm gonna sit here like a flag.
We have Q&A, that's fine. The second question is whether, and if so, when, a person in the loop is legally required, and this is a discussion familiar to those of you who've been dealing with military AI. I think that we all know that the real issue here would be when the object of attack is DPHing civilian, because when it's a combatant, it is really not a rocket science. And in this room, I really don't have to remind anyone that DPH is one of the most contentious concepts of contemporary IHL, not only in this context. It's problematic. We don't know what to do with it, and there is gazillion interpretations. It's been subject to fundamental revision many times. But I think in many discussions, the starting point of reflection is again, controversial, 2009 ICRC interpretive guidance on the notion of DPH, and the distinction they identified between sporadic DPH and continuous combat function. How do I say it briefly? Nobody likes CCF initially, but somehow it's been normalized. An original concept of CCF, which was limited to NIACs, somehow migrated to IACs and has been effectively accepted, even if not called that. So there is a number of pieces which analyze the targeting practices of France in Western Sahel, in the Sahel, in Western Africa, and the US across the board. And arguably, and I know that this was gonna be a point of discussion, it appears the prevailing view nowadays is that members of an organized armed group may be targeted in a similar way to members of state armed forces. So kind of a blend between, so there's a blend between functional approach and status-based approach. But again, the use of facial recognition technologies to target civilians DPHing, however we construct them, has benefits and pitfalls. The pitfall is, and I think this is a major issue here, is that targeting, assuming the technology will be widely used and reliable, we can turn targeted killings, it's already been done. We can normalize the fact that targeted killing is punitive rather than preventive in nature. I think that this is the major risk attached to facial recognition based targeting. But arguably, the major benefit is that it increases compliance, or it has the potential to increase compliance with the principle of precaution. So we will know more about the target, simply put. Conclusions. We don't believe that the use of facial recognition by armed forces for targeting violate any rule of IHL as such. It all depends on the use, as it is with many technologies. In some cases, facial recognition will increase compliance with IHL obligations. But again, it's crucial, what do we do with it? There is a big discussion, as for the discussion on whether or not having a person in the loop is required. I think that for now, the safe way to look at it is that for as long as technology does not perform as well as an average human, we need a person on the loop. Once the technology is more reliable in recognizing targets and faces than a human would, there is no legal reason to keep a human in the loop. But there is a major if there, depending on how the technology performs. Anything else?
When you say human in the loop, do you mean in the sense of recognizing the face?
So,
I think it's a set, like a second
Because
layer.
there will be like this, it just collects right information.
so in the paper, we give two test cases. Two test cases are, we have a drone that is flying, an assault drone that is flying, and its aim is to do targeted killing of a specific person. The drone can either identify the person, confirm it with a person, that person is in fact the commander, that target is the person that we are looking for, and then attack. Or we have the alternative one that the drone is being received the order to target a specific person, identify that person, and attack it. And this is the difference of the person in the.
There's this third option, which is the more plausible one, where the drone recognizes the person, but ask for an authorization to attack without the person in the target room actually going through the picture and look to see.
It's an authorization of a different thing.
So I mean, the human in the loop doesn't verify the act of facial recognition, but the decision to attack this person based on this.
But because technology right now is not at the level of human identification, if we get out of ideal conditions, and ideal conditions is when you go to border control and you look at your passport, and your passport was taken in specific mechanism and specific camera that allows you to get the perfect face print, where in the field, it's impossible to get that good picture to compare it, even if you have originally had that perfect face print, which you usually don't. Then if you, under these conditions, you're not even close to the 97.53, which has become my favorite number since we've started this. So
your argument is therefore that it is legally required to confirm every identification.
Yes.
For now. For now, yes.
At least until
the technology
improves, and when the technology improves, we can have a further discussion about whether or not it would be relevant or not. But at this point of time, you must have a human identification prior to the targeted killing. Yeah.
Can we just step in, Magda? Was that the end? We are smoothly going to the Q&A, and we only have 10 minutes for it because we're approaching half of the panel. So if anyone wants to pose a question or discuss, now is the time, please.
Should we do both of them and then?
Or is that better, you think? Do
whatever you like.
Yeah, otherwise we would spend all of our time on the first Q&A. And
if you agree,
is
it okay? Okay, then maybe it's a better way to do this, and then we hopefully have about 20 minutes for Q&A. So we will now hear the second presentation by Shiran Shahaf, who actually just recently obtained her PhD from Deakin University in Australia. Congratulations once again. And she, next to that, holds a BA in International Relations and Arabic Language and a Master in European Studies, both from Hebrew University in Jerusalem. And she's now back to Israel. I confirmed that. So this time, hopefully, I'm not lying, working in the industry. So kind of putting together her academic and practical profile. Shiran, the floor is yours.
Thank you. What? This one? Hi everyone. Great workshop, everyone, and great presentations. Really interesting. And I will talk about applying international law of cyber warfare. My presentation will present the challenges in applying conventional international law to cyber warfare. I will briefly talk about the Italian manual, and assuming that you know what it means, but it's really related to my research. And after that, I will present the legal gray zones with the application of international law to cyber warfare, and the most important part of my research is the legal positions.
I'm terribly sorry. I just want to warn you that in like 2 minutes, it will be a mock test of sirens so you don't get nervous. It's perfectly normal.
Are we in Israel?
Yeah. we
Welcome home.
Don't worry, it's in the streets.
Why?
It's a test of sirens.
Okay, so you know
Test regularly.
The sirens, or they're testing the
Sirens. No, the
Not
sirens.
supposed to do it.
No.
I think it's funny.
So,
Sorry.
Where is the nearest shelter?
Okay. Please,
we don't need to go
Shiran.
to the shelter.
Sorry.
It's okay.
Thanks, Jacob.
And then I talk about the legal position of states and international organizations regarding the application of international law to cyber warfare. And of course, I will touch on the human rights aspects with this application. So a brief introduction of the Tallinn manual for those who are not familiar. It's the most comprehensive and non-binding, important to say, instrument today applying international law to cyber warfare. It was initiated by NATO and created by a group of experts directed by Professor Michael Schmidt, who the purpose of this manual is to apply international law to cyber warfare and interpret all the existing laws to this modern field. The most important thing is that the Tallinn manual agree unanimously that international law generally apply to cyber operation. However, they present and also these gray zones are present in my research, many gray zones and unsettled issues and unsettled questions when applying this the international law to cyber warfare. So these legal gaps and gray zones are the main issue in my research and in literature. And I could identify, the literature identified like 8 gray zones when applying international law to cyber warfare. Of course, I don't have the time to talk about all these gray zones, but well, now I feel Israeli, definitely.
You can continue.
Okay, ignore. So we'll only talk.
It's a different version of the cyber. It's fine.
Yeah,
It doesn't go up and
I
down.
think it's not. Yeah,
Yeah.
it's less stronger. I think. Yeah.
So it's like when the Shabbat enters. We are high. Okay, sorry.
Okay, so I forgot to say that the manual, of course, apply customer international law, treaty law, UN charter, and so forth. And the gray, so I will talk about 2 gray zones, I think, which are the attribution, because attribution is the most, I think, the most significant problem in applying international law to cyber warfare, and due diligence also have its relation to human rights. So I just bring these 2 examples. For now, just to say that, for example, under the gray zone of due diligence, we have a couple of questions, unsettled issues. Like in the cyber context, due diligence principle, like in the regular like warfare, states are obligated to ensure that their territory or do not are not used to hurt human rights of other states, of individuals in other states. And in the cyber context, it's that the territory and assets, which is you have a sovereignty, are not used for cyber operations to cause harm to another states. So one of the challenges is concern the level of knowledge and information that you need to provide in order to prove that due diligence was violated. So the question is whether actual knowledge are required to prove this violation, meaning that it's based on a clear and reliable action, or whether constructive knowledge is sufficient. I think we talked about it earlier, that they should reasonably have known that they should reasonably have known that about the misuse of the territory, based on other information, based on past events, that this attack should have come. So I will elaborate about it when I get to the state's positions, but just to clarify what I mean when I say gray zone. And also the attribution and state responsibility, of course, that while it's agreed that the customary international law of state responsibility applies to cyber warfare, attribution is a core problem. And one of the key questions is whether attributing a cyber operation to a certain state, of course, it need to be an absolute certainty or a reasonable certainty. Again, absolute certainty means that the effective control of a state on a non-state actor could have been proven by no doubt, or that it's enough to say that a reasonable doubt can be exist in order to attribute a cyber operation to a non-state actor, to a state's, to a cyber operation conducted by non-state actors to a state, attributed to a state. So I move on to the state's position just to share with you my inspiration to the research that, like I said, Professor Michael Schmidt was very dominant in my research, and I read a lot of his articles and papers. And when I saw this statement, his statement that he say will be likely be left to states to address gray zones through state practice and expression of opinion use. However, because most states practice in cyberspace is classified, the bulk of the heavy lifting will likely have to be accomplished by opinion use. So when I saw this, I said to myself, and they were all already published positions, legal positions of states regarding the application of international law to cyber warfare, but not all of them were published. So I said to myself, why not collect all positions as a step forward to a customary international law, of course, in the future, like we talked about when we have the practice in, 10 years, because we still need the practice as well. So this one inspired me to collect these positions, and I argue that this position can contribute to a development of customary international law in the future. So, of course, for customary international law to develop, we need, like I said, state practice and opinion use. And for now, we can collect the opinion use. And I must say that, of course, my data set is not completed. I could not reach to all countries, but it's a beginning. I wish I will further research this area as well by new publication of states, or maybe to reach a publication in another way. And then I thought, until we have this practice, and until it takes time to develop a customary international law, and also we do not have the practice for now. So we can use also the dispositions for soft law instruments, which are non-binding instruments, and then I also collected legal positions of international organization, and not only states, because non-state actors or international organization can influence lawmaking processes. If it's like soft law, they can influence. So if we look at what we have today, we have the Tallinn Manual, which is a soft law, in fact, a soft law that guides states' behavior in the field of cyberspace. And also we have ICRC reports, for example, the ICRC, the International Humanitarian Law, and the challenges of contemporary armed conflict that examines the unique challenges of cyber warfare in IHL. So we have today like a soft law, and I aim to contribute with these positions I have collected to existing soft law as well. A bit really brief of my data set and methodology. So I managed to collect positions of 34 countries and 3 international organizations, NATO, ICRC, and the African Union, which the African Union there are 55 member states in the African Union. So, but they did not, the African states did not publish individual positions, but rather they published the common position, the CAP it's called. So I managed to collect these countries and organizations, and I took the positions were published in official website, interviews, speeches, strategies, documents of states, and so forth. Many different kind of documents, and when I could reach in order to took these positions of states and international organizations, and how can I just. Okay, the questions, when I collected the positions, I created the question as a yes-no questions for each question under each gray zone. And I created the spectrum that, how can I click on the window? Yeah, thank you. And then you need to go and then you need to go back to the slide, okay? No. So I created the question as yes/no question, and then analyzed the positions when we have wide agreement regarding certain questions. No wide agreement means that most countries agreed about this question. We have no open dispute when some question, whether it's not most countries, but some countries agree about something, but no other countries say the opposite. So it's no open dispute. And we have disagreement, of course, for questions that were contested and clearly was like one state said no, one state said yes, and we have a contestant, so it's disagreement. Please come back to them. Yeah. And I will not, of course, it's, I can, yeah. Okay. I will not talk about the selection of countries because it's long, but just to say that they were not selected in random, but rather under some categories. And now I will show the examples so that you understand what I mean by collecting states' positions. So under the due diligence, which I introduced in the first of the presentation, I have four questions under this gray zone. And we can see that for the basic question is whether the principle of due diligence apply at all to cyber operation. First I have the basic question. And here we can see that we have a disagreement, because although most states say it applies, but two important states, the UK and Israel, say that we don't have enough state practice and opinion US in order to state that the due diligence apply to cyber operation, and therefore I consider it as disagreement. And of course, so I also put the Tallinn manual just for comparison, just to see what their position, but they are not included in the analysis. So they say they agree with most of countries that it applies. And after that, we have a continuous question if it applies. So if it applies to cyber operations conducted by non-state actors, and here we have no open dispute because no one rejected to the notion that it applies. And after that, we have the matter of results. If it applies to cyber operations resulted in serious adverse consequences, and here we have many countries said that it does, but the African Union they said that that it does not apply because due diligence is not a matter of conduct. Sorry, it's not an obligation of result, but it's obligation of conduct. So it doesn't matter whether the consequences are serious or not. It does not. So it doesn't matter. So, and the last question, which I talked about earlier, and it's also, and here we have a strong disagreement. It's about the violation of, about the required knowledge, whether we require an actual knowledge or a constructive knowledge. And here we can say that we can see that they were contested about this. About this question, and so we can say that we have, regarding, based on my analysis, we have 3 disagreements under this gray zone and 1 no open dispute. And for this gray zone of state responsibility and attribution, we also have the basic question. So we also have a wide disagreement that, of course, the law of state responsibility applies, and then for cyber operation conducted by non-state actors, also we have a wide disagreement and no open dispute for if you should disclose or not disclose the sources you have when you attribute cyber operation conducted by non-state actor to a state. We have no open dispute, but we have a disagreement in the last question when if it has to be absolute knowledge or no, wait, I missed. It's similar to the. It's not a wait. Actual absolute certainty, so not knowledge, certainty. Absolute certainty, or is it enough that we have like reasonable certainty? That's the word, reasonable certainty. And here we said only one country said that it has to be absolute certainty, as well as the Tallinn manual, by the way. But I still consider it as a disagreement. So. These are 2 examples of questions, unsettled questions under the 2 gray zones. We also have of course, application of IHL to cyber operations and all the questions. There are many questions also there, but. I just want to talk about the overall findings of my research, not only the one who concerns the gray zones I talk about, and this is an important part, I think. So I could see that there is a wide agreement. One of the questions regarding the gray zones of the gray zone of use of force, self-defense, and IHL. One of the questions was whether whether it's considered the use of force, for example, whether it triggers the right to self-defense, whether it triggered IHL, if the effects are such or such. So we have a wide agreement for all these gray zones when the effects are similar to traditional effects, like if it involves physical damage, injury, or death. However, when it comes to loss of functionality and other non-destructive or non-kinetic effects like political effects, economic effects, when it's not like death or injury, but it still hurt, I think, human rights and other aspects of the country, there was no wide agreement at all, and even disagreements. We could see disagreements about the gray zones of self-defense and international humanitarian law, when countries and international organizations and the Tallinn Manual itself did not agree that loss of functionality consequences like trigger the self-defense or international humanitarian law. And also we have findings regarding the involvement of non-state actors. Here, actually, we have a disagreement, not a wide disagreement, an agreement, not a wide agreement, but an agreement that, like we saw, the principle of due diligence applies to cyber operations conducted by non-state actors. And also, in my analysis, we saw that the IHL applies to cyber operation conducted by non-state actors. So also we have this finding regarding the non-state actors. So as I said at the beginning, I think it can contribute to the development of all this can contribute to the development of customer international law and soft law, as I said, via opinion juris. And for the soft law, I think it can contribute to the emerging process of the third Tallinn Manual, which is in process now. And I think they can extend, because today the Tallinn is only expressed views of the experts within the Tallinn, but we can extend it maybe to see positions of states, and it can extend the discussion about all these applications of international law to cyber warfare. And the last slide, it concerns human rights. That just to say that with regards to what I said about the effects in the agreement and disagreements regarding the effects of a certain cyber operation. So cyber activities may violate human rights. This we agree. For example, cyber attacks can attack critical infrastructure of states. So the obvious example is, of course, if we have death or injury or physical damage, where we know already that we have a wide agreement regarding this issue. So, of course, it can violate the right to life because it hurts, it causes to death. But what about the loss of functionality that I talked about? That it's not an agreement within my data set, but it also can violate human rights. Like if, for example, cyber attack. There is an attack on electricity or water, critical infrastructure of a country, and it can cause to like in an hospital or something. That in an hospital, if there is an attack in an hospital, it can cause damage to like sick people or something. So it violates the right to health or well-being. And also I have an example of if it attack a water infrastructure that I don't remember the exact example, but there was such an attack that it caused the water to be not pure or something, and then it hurt people. So even if it's loss of functionality, where we saw that there is a disagreement, we still can see a violation of human rights. And of course, like we talked about all these 3 days, of course the personal data that most cyber attacks attack data of individuals. They can steal data, they can alter data, and this is of course the violate the human right to privacy. And also under the IHL, we have one question. I will bring only one question because it's very relevant for hackers. There is an unsettled issue, and I think it's also contested, that if hackers are protected under the IHL, because on the one hand, hackers are civilians, and on the other hand, hackers participate in cyber hostilities. So it is a contested, relevant question also today under the gray zone of IHL, which is also related to the human rights context. And this just to mention that the Tallinn manual relates to the international, like this ICCPR. He applies it at well, but my research covers only the law 4, so I did not cover the application of international human rights law to cyber operation, but in the literature they does talk about it both in the Tallinn and among states. States in their positions, they relate also to this issue. I cannot tell if there are gray zones or not. I believe there are. And for me, it's for further research. That's what I'm planning to do. One of the ideas for the further research. And that's all. Thank you.
Excellent. Thank you very much. And now a joint discussion for both. I saw Yael, I saw Mark, I saw Jakub. I will be giving it the floor.
Okay, so I have two really interesting presentations. Thank you. I've got two informative questions, and then something more substantive to Magda. So Shiran, first of all, I'm just wondering about you said the selection of countries, and I'm wondering why at this point not just at least attempt, or maybe I misunderstood, attempt to collect information from all states, because ideally that would be the data set, not anything, instead of dealing with what is representative, just look at the entire universe of cases. Also, I'm not sure whether you counted the African Union and the other organizations as one or as 54 in the case of the African Union. Because if all states align themselves with a statement, and I know that when they don't, I know it's something very specific for Morocco, that when they didn't align themselves with the position, they made a point of not doing it. So doesn't mean by application that the rest of them do align, and then it's 54 rather than 1. So this is about the count. The informative question to you guys, the point is that facial recognition is not yet in operation, and I'm thinking it's kind of the same issue or
can possibly be. We don't know. We
don't know, and it's not yet in operation, but might be are two different things, because maybe it is and we don't know.
Yeah.
But assuming that it is not yet in operation, I'm thinking I tend to have the same question about fully autonomous lethal weapons, or not lethal, that are not yet in operation. And I'm just wondering, is there experience of other weapons or tools that were discussed before they became before they were put into practice? Because I'm wondering whether one day we'll discover that these entire discussions were besides the point, because reality is different. But we were discussing what we were discussing as potential simply could happen in a different way. And I don't know if there's experience like that in the past, that things were discussed before they were actually there. And then the more concrete question is regarding question: can we infringe on the right to privacy of the entire population in order to make the identification more accurate? I think that was the question, right? Like create it kind of reminds me of the debate about the early warning procedure that the IDF applied, that in which it violated the right of a specific individual in order to minimize the risk to uninvolved civilians. So, and I mean, that was the argument. Now that we can no longer use the
Johnny procedure.
The
Johnny procedure.
Johnny procedure?
Is that the Hebrew translation, Johnny?
Was it the knocking the roof?
No, that's early warning. That's why I realized it. But although the same argument is actually applicable there, that you have a terrorist in a house surrounded by civilians. Okay, this is how it's. And you want to make sure that you target only them and not everybody else. So you ask the neighbor to go and knock on their door and say, listen, the army is here. Everybody who's not involved should get out, so that they only target the real target. And then the intention is to let all the uninvolved civilians leave and protect them, but it's done at the cost of taking a single civilian and inviting them to help and very clearly and directly violating their rights under the. And the argument was, well, what we're doing is actually trying to save lives. And I think the answer to that was, well, if you cannot save more lives legally, then don't. You're not. This is what incidental injury is all about. And I think, and I wonder whether that's the answer here is not on the same lines. If the only way to make the identification more accurate is by violating the rights of a lot more people, then or by infringing on the rights of a lot more people, then maybe that is not a legitimate way of doing it because the cost is too high. And if you cannot identify the person, then maybe you don't target them. I mean, it would be the same kind of argument. You can see where I stand on this, but whatever the answer is, I'm wondering whether it's not simply the same kind of question. The military is not required to do everything they can.
I hear you, and I think it's a legitimate way of approaching the issue. Two comments. One, I don't think that facial recognition is going to be a new weapon. It's going to be an extra layer of, target acquisition added to the existing weapons. So I don't think it's necessarily the same thing as fully autonomous. It's a whole different debate. Right. But I understand the analogy. As for the infringing on the right to privacy, I'm definitely on the other side of the discussion because I think that if we are fine of giving our biometrics, the question is about the extent of infringement. If we are okay with giving our biometrics to states for biometric passports, and then
if we are,
but this is the trend across the globe, right? And then this data is exchanged, and then different states collect when you enter the states, you give your fingerprints, right? This has been normalized. So if we do it to go shopping in New York, is it really such an infringement if the same data is collected for national security purposes? I don't think so, but it's a value judgment.
Can I counter my co-author? I think in that case, we are giving our biometrics.
Because
so I don't have to go to the US. I don't have to give Facebook my facial print. I do it because I choose. In this case, the state is doing it with or without my consent to get the information. So these are two very different situations. I do think that there are ways to prevent, as I talked about, the ping and ring mechanism, which helps us to reduce the damage to privacy. And the question is, do we collect all the information, or do we use existing databases? And these are also two different approaches, which prevent some protective mechanism to reduce the damage to the right of privacy. And I'm not a real speaker here, so I want more than that.
If you can move on, I have Tomasz and then Marco. Wait. Sorry.
It's okay.
Also, I'm
on the list.
So you ask about the African Union. You ask whether or why?
Did you count them as 1 or 50?
Yeah.
Also, what's the selection of countries? 54.
No, 55.
So Morocco's back?
50. There are 55, but no, it's one position. It's one position. Okay. All my data set is 34 states, and that's why I consider them as an international organization rather than state, because I don't have individuals. I still don't have individual positions of African states for what I checked in And that's relates to the second, your second question, why not extend the data set, if I understand, why I did not collect more positions. So I must say that at the beginning of my PhD, this was my purpose. I had a dream to collect all, I don't know, almost 200 states. And then me and my supervisor were realistic, and due to limits of time, we couldn't. And also due to COVID, and couldn't do it because we planned to do actual interviews for states, to like reach officials in states and collect unpublished positions. That was my initial purpose. And unfortunately, due to limit of time, I couldn't. But again, for further research, it's one of my ideas for further research. Thank you.
Thank you. Great presentations, very well structured, very relevant research for both of you. My question for Magda is that I think you're correctly identifying the key problem of false positives. My question would be whether you perceive it as a problem of distinction or rather of proportionality, because when you look at the statistics, the number of false positives may be higher than the number of true positives, even with 99% accuracy. That's the false positives paradox. It's kind of a portion of, say, legitimate targets in the set of available objects. This is also the paradox which explains why more vaccinated and unvaccinated people were hospitalized with COVID. So to me, this seems more like a proportionality calculation. It's easier to do, and it's also easier to do in cases with base probability an object to be targeted is high outside, let's say, civilian populated areas. So I would just like to know your opinion about this. And I have a comment on the second presentation. When it comes to legal gaps and gray zones in international law that focus on operations. Well, right now there's the open-ended working group at the UN that's going on right now. So we have certain lines to take there, and we always have to say we are helping our foreign affairs with this. So we have to say that there are no gaps, and if there are, they are only in places which are already unclear in non-cyber contexts. So we have to be careful with our language on this. But if we discuss it perhaps more fundamentally, it's perhaps a problem of analogy versus extensive interpretation. So if there's a gap, you need some analogy to cover the gap, whereas if there's just a gray zone, you use some interpretation to just decide it.
So what do you mean you have no gaps? We still have these gray zones. It's not solved.
Yeah, but it's more. I think it's more of a fundamental problem.
Okay, you talk about
theory.
Okay.
And actually, I checked in the Tallinn manual when it uses the word analogy, and it's in several places with regard to definition of attack.
Of course, I have a comprehensive definitions in my PhD. I different between cyber attack, cyber warfare, cyberspace, because it's really relevant. It's really important to understand what I mean when I say cyber operation, cyber attack, and it's related to the gray zone. So,
and also with I'll just finish the comment. So the only major institute or major concept that is labeled as covered by analogy in the Tallinn manual is actually the due diligence. I'm not sure if that's intentional, but that's the only place where I see the word analogy. So yeah, you might be onto something.
Okay, thanks.
Oh, very briefly, good question. It's a nerd question. I like those. Off the top of my head, it's distinction problem. But I understand your framing of the issue. I think that it's a distinction problem that has consequences for proportionality analysis. But to me, the way I see it, it's automatically a distinction issue. But now when you phrase it this way, I have to think about it again.
I don't have the answer. Just ask it.
Well, Magda, thanks. So Martha wants to start.
So thank you. A couple of points, Shiran, too, on the tailoring manual. So I'm together with Mike and Lise, where we're editing the third manual. And so I can assure you that the positions of state and international organizations will be reflected in the third manual. So, you know, the way we will draft it is we will say, and then such and such, so many states have said X, Y, Z, so that is meant to be in the third manual. The European Union 2 weeks ago came out with a common position, which is quite rudimentary in some aspects, but is relevant for some of the rules you're looking at, like due diligence. Methodologically, I do have to reiterate sort of the IL's core point. I don't think you can count AU or EU as one.
Okay.
I mean, because unless a specific state disassociates itself from a particular view,
that's the point of a common
position. The point of a common position. So AU counts for 55. That's what it counts for, and so you cannot say the view of the AU is equal to, say, the view of Israel on point X. No, it's 55 states saying one thing and one state is saying another thing. You see what I mean? The fact that Israel is a cyber power and none of these states are is a different issue. You see what I mean? But it's 55 states. And the same goes for the EU thing. And I mean, like for your future project, the cyber toolkit does gather all of this stuff. So, I mean, it's not like it's difficult to find. When it comes to these official position papers, they're all easily available. So you can't really not cover all of them.
And if it's not published, I'm not sure to what extent it counts.
Exactly.
It goes towards customary international law, because something we don't know about.
So I can
give is what states have they do. No, but as opinion of yours, if you don't claim that is your view,
it's a problem.
Yeah.
I have talked to one African diplomat recently who said, we don't necessarily agree with some point in the African Union paper. And I thought, darling sugar puff, unless you come out and say that, yes. So it's a huge problem because you publicly said X. So if you don't say Y, probably it's your problem. Like it's your embrace. Magda, on your paper, so I don't want to beat the dead horse on the extraterritoriality problem. I would just say this: when you say it has not been overruled, Georgia Russia number 2, it's not just that you're relying on what is really a hugely controversial judgment that cannot be defended on any point of principle. It's that when you say it hasn't been overruled, it has been, kind of.
Sure.
So, couple of cases. So in the Carter case, which deals not with armed conflict but with killing.
There you go. It does not deal with armed conflict.
But the question is the idea, the distinction that the court itself offers, does it make any sense? So in the Carter case, which is killing Alexander Litvinenko by poisoned tea, the court says the convention applies. Tell me a reason of principle why killing someone with poison means the right to life applies, but you kill them with a missile, the convention does not apply.
No, that's the difference between human rights and
that's a different question. That's a different. Sorry. That's not the question. That's a question of how the two different bodies of law apply at the same time. It is not the question of answering why does the right to life not apply.
No, Marco.
Sorry. I'm not done.
Oh, you're not.
So then, never. Then in Ukraine, Russia, the admissibility decision in the big case, which will be decided within months, the argument about context of chaos, which would mean, if translated directly, that none of the hostilities in Ukraine would be covered, except stuff like Bucha. Yeah. The court rejected it already. It said we're joining this to the merits. Everybody knows that for Ukraine, they're going to depart from Georgia Russia number 2. The question is to what extent.
Yeah.
You see what I mean?
Yeah, the legal paper will be published
before that.
Well, maybe. And then the final point is the case that I mentioned. I think you were not here, which is this Vider and Guarnieri case against the UK, when the court rules that data that is processed in a state's territory is within its territorial jurisdiction. So if you have, certainly before a conflict starts, so you build an AI facial recognition model. When you're training it, when you're building it, and you're using people's data, and the data of people could be your people, could be people from Mongolia, could be people from I don't know where else. The current case law of the court says the right to privacy applies. So I don't think you could, let's assume it doesn't apply. You see what I mean? When the court basically has already ruled that if you process people's data on your territory, the right does apply.
But Marco, I'll ask a different question. Is it today legitimate to say, I'm in a paper going to write on the IHL aspects of the matter without touching human rights?
But they touched it.
He won't read it, that's all.
Can I would.
So by the way, I'm perfectly fine with using facial recognition and targeting. So the question is precaution, do everything you can to verify the identity of the target. If you have the technology, maybe you actually have to use it if it will make your targeting more accurate, right? So I don't oppose the core argument. The question is, can you just pretend human rights law doesn't exist? Can you pretend the right to privacy doesn't apply? I don't think you can.
Okay, two comments. One, I don't think that the Twinienko case which has no reference, either legal or factual, to an armed conflict, can overrule the court's decision on the concept of chaos in active hostilities. It's just, it doesn't match. And on the processing of data, we anticipated that and excluded this from the scope of the paper. So
building the facial recognition model, which is where a right to privacy violation or at least interference happens, is outside the scope of your paper.
We focus on combat employment. We acknowledge that there is a bunch of legal aspects.
Buy it, and again, you build it, you buy it, you decide to use it in principle before the conflict.
But as I said before, you have precautionary measures. For example, I can use Interpol database, which I have never used. I just take the picture, I send them the ping and ring for the ping and ring mechanism. They have the database. They have done all the facial recognition and privacy issues. I have no violation of privacy on my territory.
Maybe you're right.
And then that's,
so maybe, but you're justifying then why the interference is justified. All I'm saying is that it's really difficult to say for something like this, using facial recognition, training the thing on the basis of the private data of how many millions of people, that the right to privacy is irrelevant. I mean, you're losing an audience immediately when you don't have to, is the core audience, the core point I'm making.
The Red Cross review doesn't agree. They accepted the paper.
But what a point. Another reviewer says,
one more sentence. What I think, first of all, nobody knows what ECHR will do because it surprised us a number of times over the years. But what I think is likely here is that they will give more meat to the idea of the context of chaos in active hostilities. This is where I think the distinction can be drawn. But for now, we'll see. It's like reading tea leaves. It's the ECHR.
Wow.
I think that will be the next move.
Can I respond to
May I please suggest we have 5 minutes left and 5 people who want to speak, so I would collect everyone who raised their hand already, and then I would give the floor to the speakers to wrap up.
One administrative, I'm using my privilege.
You're extending the time.
As co-author and the manager here to extend a few more minutes.
Yeah. We have until 1 o'clock?
Until 1 o'clock.
Until 1 o'clock. Okay. So then
can I respond? Okay.
Especially not here. We don't go.
Everything good. You going? No. Oh, so, first of all, good to know that you are one of the directors of the Italian Manual. And I'm happy to hear that the state's position will be reflected in the third one. And it's, I think it's obviously very important. And also thanks for letting me know about the EU common position, because I'm excited of every position that come out there. And regarding, for both of you, regarding the EU, just to clarify, it was not collected as a state position. It was collected as an international organization position. And the difference is that when I talked about the customer international law, it's only for states. When I collected international organizations, it's for other like soft law instruments, like I said, but it's not, I know I can't use this position as a state position.
You can, because
you say I can? It's 55?
Yes.
The process
changes the balance.
I consulted about this with
not with us.
No, not with us.
It was approved at the level of heads of government and state of the African Union. They all signed up to it. right?
But you just say someone does not agree.
No, so when they disagree, then on that point, they note it. And by the way, the one thing I know has nothing to do with cyberspace.
So they have to be vocal.
It's Morocco saying it's okay to use force.
Yeah.
So they all agree. It's the position of all these states.
So first, I think we need to understand how they make their decision, and then to understand whether I can relate it to as a state position.
Right. Okay. Exactly right.
Thank you very much for this.
Okay, excellent. Then we have a question online from Amnon, so please speak up.
Hi. I'll be very brief because again lunch is coming. A couple of methodological questions. First, I think that Yael's point on when should we regulate and when should we think about regulation is particularly, I think, acute when it comes to technology, because when we don't know exactly how the technology is developed and deployed and what is its overall ecosystem, it might be too soon to make some conjectures. It doesn't mean we shouldn't think about it, but I think it's sound to say what the paper says actually, and that is we should wait. However, having said that, I actually don't think, again, methodologically, that we should count an organization of the EU as an actual assent of all the member states or the African. Why? Because sometimes when you speak as a supranational organization, some states say, well, I don't want to actually be the persistent objector. I don't want to state that, it's just an international organization. It counts less for soft law purposes and not necessarily. So I would be more careful on that. However, I do think that there is a methodological problem with Shiran's decision to say that it's enough that Finland disagrees or Israel and the UK disagrees to say that there is a disagreement. I find this, we have the, consistent director. If it's a custom, we know that, but I would actually think that it should be highlighted differently. If 24 agree and one disagrees, I think it should be highlighted differently. And I do think the point about whether somebody is a cyber power or not is actually important. Because if you want to know what actually develops in terms of the actual uses, it's more important to look at those who are in a position to actually make the decisions, and these are those who have the capabilities. Okay, this is the issue of methodology. With respect to the actual paper on the facial recognition, I totally agree with Marco here. I must say that you can technically say, well, somebody else builds the database, I just ping. So it's the problem of somebody else that builds a database. They may be violating privacy. I'm just pinging for authentication. But I think so you can do it, provided that you highlight it so strongly to say that you totally realize that for this to work, the entire ecosystem may be premised on pervasive violations of rights to the extent that you think that these are indeed violations of rights. And here I actually think that the issue of consent is less crucial. You can say, well, I choose to go online and then I can just not go online at all. But this mechanism of consent is now currently in decline in the law and technology, because you realize that you can choose. Sure, you can choose not to give your data to anybody and then stay in a cave if you want. So, and the fact that you gave it by choosing to give it doesn't then alleviate the concerns that underlie the right itself. So I would be more careful on consent. So to reiterate, please make sure in the paper that you realize that there are ecosystem problems here. The second ecosystem is not just the collection, it's the other ways of deploying. So you can use AI on facial recognition and to say people who look like that are more likely to behave in certain ways, but I'm just using it for particular use. Okay, so there's a problem there. The only last comment I make, and again, I'll be very brief, is I think you should be more careful in terms of your use cases. And I'll give a couple of examples which reflect to ruling out. You just say, I want to identify the hay in the hay to say that this is the hay, but there could be two cases, important cases, that you want to make sure that this is not the hay. Mm-hmm. One of them is the questions that we currently face in Israel, and that's a question of hostages. So if there's a hostage there, and you know that that's the hostage you don't apply for. So you need the hey to say don't attack, number one. Number two, you want one way to say that this is the hey is to say, well, I actually have, and that's a question of privacy, which I think you have to address. If you have the ability to sort of a much wider surveillance system, and one of your sensors picks up that particular hey in some other location, then you shouldn't attack because, yeah, it's not the person you want to know. But for that to happen, you have to have very robust surveillance in all other places. So I'm just saying that the use case is a little bit more complicated. And again, the distinction I think we should make, and we should have made it also yesterday when we talked about autonomous weapons, although these are different contexts, is between offense and defense. So sometimes you need to be really quickly when it comes to defense. So no time for human intervention. Missiles are coming. You just have to allow the machines to work just because they work faster. But in offense, sometimes you have to wait and think. So I think Yali's comments that there should be an authorization, not necessarily for the identification, but definitely for the use, it should also be highlighted in the paper. These are my comments. Thank you.
Very much. You want to respond? You want to respond?
Maybe just very briefly that most of it is covered in the paper. It was a very simplified presentation, but most of it is in the paper. Not all, but most.
And I just want to say that I totally agree with you about the feeling, about this. It can be a disagreement with only one state saying the opposite. But when I ask myself, what is it? It's not a wide, I can say, do you think I can say it's a wide agreement, for example?
It's not consensus, but it's wide.
It's not a consensus, but it's wide. Yeah, okay, I'm taking this comment. Thank you. And for the other, what you said about cyber power, it's of course something I relate in my research for doing the distinction between less power. There are levels of level of technology, how it calls level of technology abilities of states. So I have this, of course, I'm relating to this as well.
Just one comment about Yael's comment and Amnon about talking about things that are not here yet. This is actually one of the goals of our paper is to reduce the fear of killer robots and say that, well, we don't know what will be, but we have to stop everything. And we also already heard about that in yesterday's presentation about moratorium from any autonomous weapon systems because the risks are so big. And our goal is to mitigate that fear and say, well, technology is relevant, can be useful, and we need to address it in a smarter way. And I think the last sentence in our paper is that technology is user sensitive, and therefore it's not about the technology, it's about how you use it. And Magda said it during her presentation, and I think this is the important thing, that we need to know what we are getting towards to, and once the technology keeps up with us, we will adjust it. But we need the discussion, in order to reduce the fear and work our way towards the development of the technology.
Thank you. Jakob is next.
Thank you both for the great presentations. I have two questions on Shiran because our PhD researchers are pretty similar. I have also analyzed the national positions, and I'm intrigued on what did you base your findings about the effective control test? Because I saw on one of the sites that there is a widespread agreement about using the effective control test, and I did not find it. So
what do you mean when?
Well, because the effective control test being used on cyber operations is, many experts already said, including Kubomachak, that this test cannot be satisfied by a cyber attack. That it is too strict. And I am interested because I know of 3 states that openly said that they will not use effective control tests. I know that Finland said that they will use, but majority, I think they said nothing about
they say
using any control.
Nothing about the test. I didn't talk about the test. Whether it's I didn't talk about whether it's an overall control or effective control. This they don't relate to in their positions at all. No country relate to this. They generally say that they can, for example, attribute that cyber operations conducted by non-state actors can be attributed to a state, but only if it's in effective control of the state and by its direction and control for the non-state actors. You know what I mean? They are not talking about. There is no discussion within the positions regarding the test. What you mean the test? You mean the overall control via the effective control, right?
I actually find from the state practice and from the behavior of the states that they don't want to call it overall test because it was rejected by the International Court of Justice, but they are trying to create something new, or they are creating by their state practice something less rigid than an effective control. And I was just
that's why they only say that if there is an effective control, they do not get into the issue with effective control and overall control. When they talk about when they talk about attributing a cyber operation to a state.
So they agree that there needs to be a control test. They just don't.
They don't specify the issue is overall or whether it's effective. Not in this. In my previous paper, I do get into this because it's not for the position. There is a discussion about it within the Tallinn, for example, but state positions do not relate to this issue.
Yes. I made my personal crusade against the effective control test throughout my PhD, so I was intrigued about that. And about the due diligence, the disapproval is getting broader than just the United Kingdoms and Israel. There is also Canada, Singapore, and the United States. And the United States actually said that they have not identified a state practice and opinion areas that would support the claim that due diligence currently constitutes a general obligation under international law, which is kind of, at least, I have applied the methodological approach of the International Law Commission and Mendelssohn, for example, and I think that with these powerful naysayers, it can be pretty much devastating for the application of due diligence as a general principle in the cyber context. And I'm interested in whether you agree with me or not. Because the international customs need to be sufficiently widespread and consistent. And if you have a United States cyber power without question, Canada, United Kingdoms, Israel, who say, no, this is not a part of international custom, it may already signal that we cannot identify due diligence as a part of international customary law in the cyber context.
So, according to my data set, it's the UK and Israel that say that they disagree that due diligence apply to cyber operation, right? Mm-hmm. So you say that the United States as well?
Yes.
Say the same position?
Yeah, the thing I just said, it's from their.
So of course, if I consider this as a disagreement with only the UK and Israel as a disagreement, so of course, if it's the United States that is the biggest cyber country, so of course it would be still a disagreement. Maybe I don't understand your question.
I'm sorry to interrupt, but I would rather move on because we still have to.
Okay, maybe you can look at it about it over lunch.
Collect them. So we collect them. So Yali and Solom, and then we will have final word of the presenters. Okay.
I'll just say one brief point to Magda in those piece. What you deal with basically is, or at least to some extent, is intelligence gathering. And I think that in a way you should maybe consider thinking about it maybe in a sense broader than just facial recognition when it comes, for example, to give just one example, to verification, right? So what do we have? We have some type of certainty that this is the actual target when you use facial recognition, but then you have the task of like the human involvement. What is exactly should be the human involvement? One option, and it seems to me that this is what you suggest, is the person takes the pictures, look at it and say whether it's the person. Another option is to have alternative intelligence sources that suggest, for example, that the person is indeed in the place or whether it's not the person, or we have other signals that suggest that this is the target. And this is basically like every intelligence operation and the requirement. And I think that at least formally, many military suggest that they need to have some kind of cooperation for any targeting decision. And I wonder to what extent is facial recognition unique in this sense, right? Whether you have like a bigger claim about the level of certainty that you need to reach in order to target a specific target beyond the other questions of services.
Oh, thank you. And someone second?
Yes, I also want to expand upon also what he said now about the level of certainty. My question is about urban warfare. Given that we know that facial recognition doesn't work when we have big crowds, and this is also tested when it comes to police operations in the United Kingdom also. So in urban warfare, we have a mingling between civilians and combatants. So the question is, what is happening then? Is facial recognition being enough? Because, as you said correctly, we have the false identification, we have the plausibility, the reasonableness. But maybe ab initio, when we have a mingling between combatants and civilians, like in urban warfare, ab initio was to say it is illegal, we cannot use facial recognition because of the close interaction between the two groups. And a common thought for Shiran, what's the thought about the Eastern customary law? So we spoke all the time and always trying to find opinion views, and I was thinking whether maybe cyber gives us also the opportunity to formulate also Eastern customary law, and finally maybe more easier to actually see the encapsulation of customary law rather than other cases because of the velocity the technology has.
Thanks. Thanks for that.
I can only agree with both comments. It was never our intention to say facial recognition would be the only source of intel. We understand that it will be used to build the layers of knowledge and used as a supplementary source of information for intel gathering. So it is reflected in the paper, and I hear your point, but I think that the separate, like going more into verification is a separate paper. It's a whole new paper. This piece came from our interest in biometrics and facial recognition being not widely analyzed for targeting purposes when we started writing this. This is where the focus came from.
Thank you. Any response?
People have thought also.
Yeah, thanks. I wrote it to myself.
Okay, excellent. If there are no further comments, I thank you. I apologize for failing to time keep, but you guys were too eager. So I hope you had a good discussion in your lunch, and let's do it in the afternoon.